Hans Singer.
Deputy Speaker, contrasted against the dire need for sincere intent to deliver a fair civic deal, what we are faced with in Rabs reflects irrational design and manipulated process. The current financial dilemma of the Road Accident Fund is a result of mismanagement, sloppy governance, deliberate interference of operations, and disregard for administrative discipline. By approving Rabs, you will irrationally be subjecting the South African public to immense financial pressure, having to fund a dual system which would result in an increased fuel levy of up to 75% to fund both RAV and Rabs for at least 13 years. This is unwarranted. By approving Rabs, you will be subjecting the fiscus to a financial burden which is based upon uncertain and unreliable information. This is irrational and unjustified. By approving Rabs, you will be legitimizing undersettlement, which is unfair. By approving Rabs, you will, contrary to the Satchwell Commission's recommendations, be indemnifying the wrongdoer, something which is immoral and wicked. By approving Rabs, you will be excluding the not economically active victim. This is irrational and definitely not pro-poor. By approving Rabs, you will be stopping general damages with any opportunity to restore a victim's financial security over the longer term, and this is cruel and short-sighted. By approving Rabs, you will eliminate a claimant's access to medical costs incurred when preparing a claim. This is harsh and punishing. By approving Rabs, you will be denying under 18 and over 16-year-old victims of a direct claim. This is irrational and heartless. Mindful of the financial agony which the Road Accident Fund has landed itself into, the DA consistently promotes amendment to the current RAF Act, acknowledging Rabs as a solution but not the only solution. This bill is far from the logical base of the Satchwell Commission's decisions and proposals of 15 years ago, and today unsupported with relevant actuarial evidence. We have offered effective measures through which the financial bleeding of the fund can be stopped immediately. Frequently, I have approached each of the 3 transport ministers over the last 4 years to accommodate such dialogue. Ignorance, however, is not to be blamed, but something much more brutal. Mindful of the fact that sessions were recorded during the public participation process undertaken in 9 of the provinces, I place it on record that only 13% directly supported Rabs. In fact, the majority complained and shared bad experiences, not realizing that Rabs will provide far less remedy and check and balances. 7 provinces rejected Rabs, of which 4 rather favored amendments to the current act. Frustration amongst the members of the committee, realizing it's not going their way, built up to such an extent that up to 17 interruptions were recorded during particular public submissions. The public participation process, supported by industry specialists and stakeholders held here in Parliament, followed the same trend, with little regard, let alone impact allowed, measured against the substantial content and quality that was offered. During the last phase of this unreasonable journey, the DA submitted a written minority view in accordance with Rules 166 and 288 to be included as part of the Portfolio Committee's report. This, in compliance with provisions which invites minority parties to specify in which respects there were no consensus, we expressed and conveyed views to facilitate this debate. Unwarranted, our report was removed from the draft version and not included in the report tabled here today. In this regard, we have approached your office, Speaker, and still await your response. Speaker, in accordance with Rule 291 sub 5 sub A, the DA requests this bill to be recommitted to the committee for reconsideration based on amendments which we have submitted, again approaching your office, yet not receiving any response. Therefore, we reject the report and do not support the Rabs bill in its current irrational fabrication. I thank you.
Thank you. Honorable Mlausi.
Redibo mdzulaji dilorine ba lehorola EFF riko aneza hoi bill uri panda because this bill is inconsistent with the constitution because of the following reason. It excludes the victim common law right to sue the wrongdoer. It does not provide for general damage or life enhancement benefit. It does not guarantee medical treatment to private medical sector. The funding model of Rabs is flawed and the Department of Transport has failed to update the actual calculations after the submission by the Treasurer in August 2018. I put it to you, none of the majority party nor the Department of Transport can state as a fact that Rabs is cheaper than the road accident fund. I put it to you that Rabs will require double the current fuel levy, that our voters cannot afford another increase in fuel levy. Government, including the Treasurer, has given us no clear explanation where government will get the fund to afford dual system. You must remember, if you want two, you have to pay two. The road accident benefit scheme will be dependent on a sick government hospital infrastructures. South Africa has the largest accident rate in Africa. We, the public, cannot afford Rabs on the financial and safety basis. It will kill our people. The ANC government is doing nothing to own up their constitutional duty to ensure the safety of our road users. The ANC government is misusing petrol levy and will continue doing so under the dual funding system to corrupt rather than paying the victims and to use the money to bail the state capture consequences like SAA and e-tolls. We as lawmakers have a duty to create a good law all for our people. The Rabs does not achieve these goals. We need to protect victims of road accident, ensure their financial independence, and provide appropriate health care. Instead of supporting the victims, the ANC government will exploit the victim, especially the poor, by having to pay more to receive less. This is not the aim of social legislation. The poor will never achieve financial rehabilitation, nor will they have long-term financial security under Rabs, as it will be simple not gain access to the administrator or to exploit as we have the current in the rough direct claim system. Without hope of the financial rehabilitation due to the absence of general damages, workers who become victims of road accident will not be able to put on the table the food for their families. Will they be able to put the roof over their children's head, close them and put them in school? Instead of addressing the administrative and the obvious management problems, government is showing their true colors by excluding the poor to get their hands on the full levies intended for victims. When the EFF governed in 2019, we look after the South African road crashes. We will send their children to school. We will make sure that the government will make sure that the victims of car accident are treated with respect. More importantly, the EFF government will fix the roads, impose public transport, and use the land expropriation without compensation to build more roads, to reduce congestion in our roads and accident. The EFF reject this bill because it won't help our people. Thank you.
Thank you, Babu Stole, IFP.
Asibonge sihlalo. Oqala sihlalo asiveza ukuthi ngalesikhathi senza ama hearings iningi lama province esahamba kuwo akukhombisa ukuthi I road accident benefit scheme abayazi. Kodwa into ababeyizele kwakuzokhalaza ngama claims abawafaka ku Ralph bengayitholi imali yakhona. Babezokhalaza ngokuhlala kwama lawyer ebhedlela abasebenzisana nolokhu no dokotela ukuthi bakwazi ukuthola ama-files zabo egcineni imali bangakwazi ukuyithola. Egcineni ke ngicabanga ukuthi iqiniso kufanele sibhekane nalo ukuthi umbuzo okhona manje ukuthi njengoba sikhuluma ngokuthi kuzoba ne-administrator ezobhekana nokunceda abantu njengoba kade kune-corruption engaka kade yenzeka ku-RALF izovinjwa kanjani manje ku-road benefit scheme ngoba i-road benefit scheme nakhona kuzobe kukhona abantu abazobe befana laba kade bekhona ku-RALF manje izo zinto efike zithanda ukukhathaza ma ubheka lo mthetho esushaya umthetho omuhle kufanele ngabe kudala wabakhona kodwa ma ubheka kunezinto eziningi ezisho ukuthi kufanele ngabe i-act i-road i-RALF kufanele ngabe silungise izinto eziningi okufanele zilungiswe kuyo kunoma senze omunye umthetho ofanayo nezinto ekade zenzeka njengoba kade kwenzeka nje kukhona ezinye izinto okufanele sizibheke manje ukuthi in this respect, if this government essentially that issues in regard to what can only be described as discrimination upon claimant, non-resident based solely upon their resident status. Additionally, the imposing of time limit on family support benefit in respect of the time frames during which family support benefit can be paid. Okwenza ukuthi mhlawumbe ngikhala ngalokho ukuthi mongobheka abantu akade limele bekwazi ukuthola ilamsamo imali akade kwazi ukuyithola njengamanje ku-road accident benefit scheme akazi ukuyithola imali kodwa kuzobhekakala ukuthi imali akade eyithola ngalesikhathi esasebenza bekumalini nanokuthi uma elimele kuzoba nemali yokuthi imbhekele noma mayishonelwe kuzoba nemali engango-20,000 ukuthi ikwazi ukuthi kuyongcwaba emva kwalapho kuzokwenzakalani imali izotholakala kanjani lezi zinto kufanele ukuthi minister ngicabanga ngokuhlonipha okukhulu nokuhlonipha ilokhu ukuthi njengamanje njengeqembu lenkatha yenkululeko kulomthetho lo khona njengamanje asikwazi ukuxhasa baba ngiyathokoza
Thokoza thina mhlonishwa Shilembe NFP.
Honorable Chairperson, the Road Accident Benefit Scheme bill that is tabled here today is controversial and is likely to have a significant impact on the lives of South Africans when it becomes law. The fact of the matter is that the South African roads are amongst the most dangerous in the world, and statistics released by the Road Traffic Management Corporation shows that more than 14,000 people lost their lives on the South African roads in 2017 alone. Chair, this is a frightening figure which we dare not to ignore when considering the intention and purpose of this bill. Some of the advantages of the bill have already been mentioned, and we are in agreement with those. There are, however, pitfalls in the provisions of the bill which the National Freedom Party believes should be highlighted. One such pitfall is to be found within the no-fault system which will be implemented should the bill become law. Our concern is that the new no-fault provision will allow any person injured in a motor vehicle accident to claim benefits, with the only exception of those who are involved in a motor vehicle accident whilst engaging in an act of terrorism. By implication, this means that a person who is involved in a motor vehicle accident whilst commissioning a crime, such as, for example, a cash-in-transit haste, will be able to benefit at the expense of those who will be funding the scheme. In our view, this is wrong. The National Freedom Party is also concerned about the appeals provisions, and in particular the provision which restricts a challenge to a decision of the appeals committee to a judicial review only. We believe that such a restriction could lead to injustice and ideally should not feature in the bill. The process to apply for benefits seems reasonable, straightforward, but the internal decision-making mechanism are laborious and onerous.
From the outset, I would like to register that the United Democratic Movement will not support the bill, as it places undue and unnecessary financial hardship and strain on all people of the country. Speaker, I'm confident that any party or member who supports this bill is not investing in the interest of this country's development, and it must simply be seen as such. Many voices have been raising concerns about this bill, and it seems to have fallen on deaf ears. The bill seeks to inflict further pain on South Africans. This bill effectively will abolish the right to general damage claims, limit claims for children and for victims older than 60 years of age, to emergency medical care. As adults, we know that funerals are expensive, and we wish to send our loved ones off with the highest degree of dignity as possible. But this bill will cap funeral expenses to 20,000 rand. Furthermore, it excludes those who may potentially be financially impacted by offering no cover for victims whose annual income exceeds the national average of 219,000 rand. In keeping with this exclusionary manner, the bill further seeks to exclude children from being beneficiaries from road accidents, as well as people over the age of 60. Finally, the bill excludes the liability of a driver or owner of a vehicle. This is unacceptable, as it erodes the accountability and sense of responsibility of road users. A drunk or reckless driver may be less discouraged to act antisocially and ensure that they are responsible for the lives of other people on the road. They will be excluded from being liable for the damages they have caused to other responsible road users, and therefore be less inclined to make sound decisions. Soon, South Africa's standard of road usage, respect for fellow motorists and respect for road rules will be so far forgotten. Chairperson, the Minister, through this bill, seeks to place no personal responsibility on road users who may commit offenses or act negligently. So often we hear of families destroyed by the road carnage. We have our emergency and healthcare systems placed under enormous strains due to unroadworthy, irresponsible, and drunk drivers. We call on the Minister to humbly retract this bill for further consideration and actually work with all South Africans to develop a better system that is beneficial for all. We will not hold the Minister if he retracts this bill, but rather celebrate his inclusive approach to addressing our concerns. Mr. Minister, kawuya liyocabanga emva, le ibill ayikho right. Thank you very much.
Siyathokoza ma. Akbarelet Alberts.
Dankie, voorzitter. After the obscene accident earlier today, where we witnessed the lionizing of the principle of expropriation without compensation, we are now also witness to the first bill to be passed that implements EWC, namely the Rabs bill. It is ironic that in those public spaces where the state does have a limited and important role to play, such as ensuring road accident victims and protecting dependents, the current government broke and bankrupted the functioning road accident fund system with that old ANC sickness of irregular governance and corruption. And now it wishes to replace it with Rabs that expropriates existing rights without compensation. So let me count the ways in which EWC is making its presence known. Firstly, Rabs expropriates into common law rights to explain or to claim against any guilty party in an accident. This, in effect, provides a free pass to those who drive recklessly. Secondly, in an insidious and irrational manner, it provides rights to those who have acted recklessly on the roads, like drunken drivers, due to the no-fault system, as they will also be able to claim in an accident that they caused. This, in effect, expropriates the right of road users to a safe travel and road environment. Thirdly, it expropriates the rights of the middle class, nurses, police officers, teachers, to participate in the scheme as opposed to the current position where they may claim from the RAF. Fourthly, it expropriates the right to choose one's own medical practitioners and relegates everyone to a state-managed process of medical care. Should the scheme only approve medical care management via the public health system, claimants will become victims of those concentration camps today known as public hospitals and clinics. Fifthly, lifetime care is expropriated. Once you become 60 years old, the scheme will abandon you. So take that, the elderly people of South Africa. We now know the ANC hates you. Lastly, The right to legal representation is effectively expropriated, and claimants are left to the devices of the scheme that acts as legal counsel, adjudicator, and administrator, a clear conflation of roles and interests that leads to undersettlements. 'n verdere kernprobleem met die wetsontwerp is dat die beplande befondsing van die skema nooit na behore in die komitee gehanteer is nie, en daar verwarring is oor die verskillende definisies van die skema. Daar is ook verwarring omdat dit nie duidelik gestel is dat daar 2 skemas is wat gelyktydig befonds moet word deur die petrolheffing nie. Road users must take note that the fuel levy is going to increase substantially due to the funding needed for both the RAF and Rabs that will run concurrently. This bill gives road users every reason to be very concerned and will surely be contested in court. And we will ask the court, when we go there, to issue cost orders against every MP personally who supported this bill. I thank you.
Thank you. Honorable Carter.
Chairperson, compensation for injury or death arising from road accidents form an important component of our broader social security net. But I want to start off with the question of how can a bill that will have serious financial implications on provincial hospitals and provinces be tagged as a Section 75 bill? Surely this bill should be a Section 76 bill. First mistake. As the Congress of the People, we have been concerned with the failure in the good, clean, effective and efficient governance of a road accident fund. The fund has essentially been insolvent and in financial predicament for the past 3 decades. At the extent of systemic fraud and corruption and wastage affecting the fund. It claims and its operations. Now, Chairperson, the status quo cannot remain and reform is needed. Agreed. However, we do not believe that the most prudent means is by adopting a dual system. Minister, a dual system. Rabs does not provide reasonable, fair and practical solutions to the problems and shortcomings of a current fund. In the first instance, we do not support the introduction of a no-fault system, as it means that both the victims as well as perpetrators of the accidents will be able to get compensation. That there will, as a consequence, be no negative outcome for negligent and reckless drivers, that the quantum of compensation granted to accident victims will significantly reduce, and that the no-fault system will merely add to the already existing financial and administrative burden. Now, if this bill is adopted, we will be further burdened by having to maintain and administer 2 systems. Yes, Minister, Rabs is not replacing the road accident fund. The DOT has not done a costing on Rabs, and it is estimated that the petrol levy will double, placing a further burden on the poorest of the poor. Now, obtaining medical and police reports with potentially no reimbursement will negatively impact on the ability of the poor and the vulnerable to access benefits from the fund. Administrative staff is now going to make medical decisions, and victims will have no recourse. There's no government rehabilitation centres in the Free State, the Northern Cape, Limpopo, Eastern Cape, or Mpumalanga. There's 6 in the Western Cape, 2 in Gauteng, and only 2 in KwaZulu-Natal. How on earth do we expect victims to travel to other provinces? 6 hours ago, you, ANC, were pro-poor, and here you are excluding the poorest of the poor. We are concerned that the bill will stop the right to general damages. 9.3 of the Constitution is clear. The state may not discriminate directly or indirectly against anyone or their social origin and age, amongst others. Excluding victims under the age of 18
Your time has now expired. Thank you.
is unconstitutional.
Thank
Excluding
you.
teachers, nurses,
I'm going to
police
switch off your
officers.
mic. Honorable Swart.
Thank you, House Chair. House Chair, the ACDP understands the need for reform, but this is not the answer. House Chair, the bill and its scheme which it seeks to establish are fatally flawed and fail to achieve the objectives set out in the memorandum. And on the contrary, it will result in extreme hardship on future victims of road accidents, particularly those who are most vulnerable in society, including children, widows, and the poor. And every opposition party here is opposed to it, and that should give reason for thought. Now, the concepts of reasonable and equitable go hand in hand, and there can be no rational basis. That is a legal requirement to suggest that it is reasonable or equitable to support condemning seriously injured children to a lifetime of abject poverty and suffering. That is what is proposed here, with no prospect of achieving a reasonable standard of living. Is that pro-poor? Definitely not. It arbitrarily limits the benefits payable to widows and dependents of deceased breadwinners. It burdens an already failing public healthcare system by forcing victims without medical aid to use public hospitals. And the total abolition of any claim for general damages for pain and suffering, not even for the most catastrophic injury. This is disgraceful, and this is contrary to what the Satchell Judicial Commission of Inquiry recommended. And we as the ACDP have deep reservations about the bill's impact, particularly on the no-fault system. So let's just have a look at it. What is the system at the moment? You've got an innocent motor vehicle driver, you've got a drunken driver. The drunken driver cannot claim. Now the drunken driver can claim. What do you have? Double the claims. What does that result in? Double the fuel heffing. It is not rocket science to understand the implications of this, and that is why the National Treasury said it is unaffordable. So let's just have a look. To make matters worse, Section 35 totally removes any civil claim that you may have. That is disgraceful. And it removes legal assistance. So the minister blames lawyers very easily. But let's just have a look. At the moment, direct claims that are instituted, there are 200,000 direct claims without lawyers. 20,000 of those have already been prescribed. That means they've got no claim. That is disgraceful. There's another example of a claim that was instituted, direct claim. 45,000 rand was offered to those claimants. Lawyers were brought in, and the settlement eventually was 4 million rand. This is disgraceful to blame lawyers. Let us have a look. The clogs apparently the courts are clogged. What is the problem with that? The RAF, because they litigate right through to the court steps, and then they are settled there. Very few of those cases go through to final trials. So, Chair, this we cannot accept. The right to claim due and proper compensation following a motor vehicle collision, particularly where one is not at fault, is a guaranteed constitutional right which cannot be sacrificed on the altar of government incompetence, maladministration, and corruption. Thank you.
Re Ramatlakane, ANC. Volge Freitas.
Thank you, House Chair. Now, from the beginning of this process, it was blatantly obvious that the ANC didn't have the vehicle crash victim in mind when considering this bill. There's much that the ANC has said about lawyers milking the fund. The fact is that the enormous RAF legal bill is caused by claims being opposed by RAF contracted attorneys, who in most cases have no legal basis to oppose the claims. The RAF have legal fees of close to 7 billion annually, up from about 180 million 9 years ago. Claims are settled shortly before the final legal proceedings. An example of this is that 80% of cases in courts are our RAF cases, with only 1% actually going to trial. The current system was developed when South Africa only had 500,000 cars on our roads, and now we have more than 11 million. And to make it worse, we have more than 14,000 road-related deaths annually, and about 140,000 seriously injured persons on our roads per annum. And there are about 70,000 claims per year. South Africa has about 156 fatalities per 100,000. The international good standard is less than 10. The ANC has been pursuing the continued narrative that attorneys are bad and stealing the poor claimants' money. The narrative is led by blind, ideologically, politically stubbornness to implement this bill at all costs. Should this bill be passed, it would lead to total breakdown of law and accessibility to courts. If Rabs becomes law, any person younger than 18 making a claim will cease to receive benefits once they reach the age of 18, and even if they need the benefit for life. Rabs ensures that anyone older than 65 will be guaranteed of not receiving any benefits whatsoever, even if they need this assistance for the rest of their lives. But this isn't the worst issue. In future, we will not only have to pay more and receive less, but those who shouldn't receive anything at all, in fact, will. The Rabs bill proposes that anyone claiming from Rabs would not require to prove if a vehicle crash was caused by that party involved in the first place. To put it bluntly, a drunk driver can repeatedly cause an accident and even kill people involved in a crash and will be able to claim from Rabs over and over again. In other words, a drunk driver will be rewarded for driving under the influence of alcohol. This sounds unbelievable, but it's true. So essentially, this government and the ANC have no problem with drink driving. Rabs will simply cement this. Thank you.
Order, honourable member, honourable.